Hello law students! This video is part 1 of an introduction to legislative history research. Quite often, the meaning of a statute is not clear from text alone. If the issue you're litigating turns on a statute section, the proper way to interpret that statute can change the outcome of the case. You may need to argue for your preferred interpretation. There are many methods and canons of legislative interpretation and competing judicial theories. One key method is finding the history behind the statute and using that to infer the policy intended by the legislators, or perhaps finding rejected language that creates a negative implication about the law's meaning. Now, these videos will not focus on interpretive methods. Rather, they will show you how you can find the various types of documents that comprise a statute's legislative history. We'll leave it to your professors and supervisors to teach you how to weave them into an argument. In this first video, we will describe the most important types of documents in a statute's history, why they are created, how they are cited, and how they can help you. Because these documents are created at distinct steps in the legislative process, we will describe them roughly in the order that they would be created in that process. So, this video tracks a law from a bill's introduction to its codification in the U.S. Code. In these videos, we will focus on federal legislation, as the documents and processes are generally equivalent at the state level. So, we begin with the bill, the first draft of a statute as proposed by a legislator. The bill as introduced is the first version of what may become law, though it will be heavily amended along the way, with many legislators having input on the final product. You can recognize a bill by an abbreviation for the chamber it was introduced in, so HR or S, followed by the number corresponding to the order of introduction for a given Congress. Some laws are instead introduced as joint resolutions. That won't affect its status as a law, though this mostly gets used for appropriations bills, which typically don't end up in the U.S. Code. These appear as HJ Res or SJ Res. But those numbers reset with every new Congress, so the citation will also have the Congress number and the year of introduction. The bill suggests the policy goals of the legislators who first introduced and sponsored a law, as well as whatever interest groups may have drafted it behind the scenes. But because it will be amended by many other legislators, the sponsor's intent is not decisive evidence of a law's purpose. Although bills are not great evidence of legislative intent, they can be used in tracking the evolution of a statute's provisions and language. Comparing what was added and removed from a bill's original form can show the priorities of the lawmakers that had input on the law. After a senator or representative first introduces the bill in her respective chamber, chamber leadership will refer that bill to the appropriate committee. That committee will greatly shape the future of the bill. Most bills will never even be considered by the committee because the chairperson can refuse to schedule it for a hearing, effectively killing it. But if the bill is advanced for consideration, the committee will then hold hearings on it. Those hearings allow various groups interested in the law to voice their policy positions, suggesting what the law should address and do. Their arguments may also involve some factual statements about the status quo they wish the law to remedy. Of course, these facts are being framed by partisans, so don't assume they are accurate or unskewed. Transcripts of these hearings are then published by the committees. Hearings are cited by the title given to the hearing, and then the Congress in which the hearing was held, as well as the year. Hearings can give you some insights into the policy debates surrounding a law and what the advocates for a law believed it should accomplish. To the extent that they introduce data, they might lead you to factual evidence, but be skeptical of sources as they appear in hearings. While these can tell you about the policy stakes, they aren't generally considered strong evidence of the legislative intent behind a statute. After all, the speakers tend to be advocates rather than legislators. After the committee members have considered the bill and voted on various amendments to it, they will vote on whether to approve the bill and report it out to the chamber floor. If they do that, the bill will be accompanied by a committee report. The committee report aims to describe the bill to the rest of the legislators, who will then vote on it in the chamber. Among other things, it contains a statement of the bill's purpose, and then, most usefully for lawyers, a section-by-section analysis of the bill's various provisions, explaining how those sections further the bill's aim. Committee report citations include the abbreviation for the respective House of Congress, the report number, which includes the Congress number before the hyphen, and the year. Assuming you're arguing before a court that is receptive to legislative history arguments, the committee report is the strongest evidence of the legislative intent behind a statute. The committee that the bill originated from had a very significant role in shaping the law, and its statements about the bill's purpose carry more weight. More critically, the section-by-section analysis is likely to describe the purpose behind the specific section you are litigating. If the report is favorable to you, this can be a valuable piece of evidence. Now, I should mention that committee reports are not generally available for Illinois legislation. It's worth noting that there is a special type of committee report in the history of some statutes, the conference committee report. When the houses pass two different versions of a law, the differences between those bills get sorted out in a special conference committee, comprised of members of both houses. When the conference committee advances the compromise bill to both houses, it also issues a conference report, which explains their draft of the bill. A conference report is especially useful as evidence of legislative intent because that draft is the last time the bill will be amended before enactment, so its author's statements are particularly informative. Once the bill is advanced to the chamber floor, the rest of that house gets the opportunity to debate and amend it. Those debates and votes on amendments are reported in the congressional record. The congressional record has daily entries that transcribe statements made during floor debates, as well as records of votes made in the chambers. The congressional record is cited in two ways, depending on whether you are looking at the bound volumes collecting each day's actions for a session, or the daily edition, where each day's actions are separately printed. The bound edition has the standard Blue Book citation format, that is, volume, title abbreviation, page number, and year. The daily edition is similar, though its page number specifies which chamber it's drawn from, and contains the full date. Statements made by legislators during floor debates have questionable evidentiary weight, but under certain circumstances, they can be used to undermine a competing interpretation of the disputed statute. They should be deployed with caution, but it can still be useful to see if there were any telling statements made on the floor, particularly those made by bill sponsors. If both chambers approve of the bill, and it's signed by the President, it is enacted into law. Most statutes are public laws, that is, they have a generally applicable mandate, though a few are private laws, meaning they benefit individuals or specific organizations. We will assume we're dealing with public laws. A public law is first published in its session law form, that is, the standalone text that appeared in the bill that was voted on and signed into law. That session law is first published as a slip law, which is later bound with every other statute passed by a session of Congress into the statutes at large. If the law has a permanent effect, as opposed to something like an appropriation, it will also be restructured and added to the United States Code. Its provisions will be included in the relevant locations in the code and might need to be slightly rewritten or reordered to accomplish that. And any section of the session law that amends other statutes will appear in the form of those amendments being implemented. There are multiple citation formats for a statute. You are probably already familiar with the U.S. Code citation, but you might not be familiar with session law citations. There are two citations for session laws. the public law number, and the statutes at large citation. The public law number is simple enough. It's the abbreviation for public law number, followed by the Congress in which it was enacted, a hyphen, and then the number corresponding to the order in which it was enacted. The statutes at large follows the standard Blue Book format: volume, abbreviation of the title, page number, and year of enactment. As you might imagine, the legislative history process most often starts with the statute. In the next video, we will see how we can find all these other documents once we have a statute in hand.